Personhood before birth actually gets judicial support. Sort of. But you will not believe what court it came from. Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yesterday, Bob Unruh at WorldNet Daily reported on an interesting and potentially powerful ruling by the Massachusetts Supreme Judicial Court. That court ruled earlier this month that a murder defendant was specifically liable in the death of the unborn child of his target. This is the latest establishment of personhood for unborn children in the United States today. While it seems to apply only to viable unborn children, even that militates against allowing people to end their pregnancies on demand up to or past the moment of birth. In fact, it sets fetal viability as a near absolute limit. Furthermore, this comes from the highest court in a blue state. Thus, the pro-life cause has its greatest victory since Dobbs versus Jackson Women's Health Organization, and has it in a blue state. Before I break it down, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I have chosen for today, which depicts a child in the womb and reads, "Not your body, not your choice." And, as in this case, not someone to ignore in our courts. One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon. Get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click that and leave me a tip. Any currency will do, so long as it's legal tender. Now, the case is called Commonwealth versus Ronke, SJC 13043. I've left a link to it in the description. This is not a case of ending of pregnancy in the usual sense. It is a murder case. A boilerplate police plotter murder case. But in fact, it is one of the most brutal murders you are likely ever to hear about in real life. I'm not going to describe it in detail. I'll just ask you to pray for everyone involved. The defendant, Peter Ronke, lived with his eventual victim for 2 years in a shared apartment in Salem, Massachusetts. Ronke, or Ronchi, however you pronounce it, and his girlfriend, they never married, did quarrel from time to time over her preference for naturalistic prenatal care. On the night in question, she apparently told him he was not the father of the child she was carrying. Now, the court found from evidence that he actually was. Now, bear in mind, she was 9 months pregnant when this happened. Well, Rocky became terrifically angry. And what he did next, I'd rather not talk about. Ghastly doesn't have to say it. I'll just tell you what weapon he used, a hunting knife. That will become important later, when I discuss the Supreme Judicial Court's ruling. The district attorney charged Ronchi with 2 counts of first-degree murder, 1 each for the girl and her unborn child. Ronke never disputed stabbing the girl, but he contested the first murder count by claiming provocation from her revelation of infidelity to him. The count, he contended, should have been voluntary manslaughter, not murder. He also contested the second count by saying his knife never touched the fetus. Therefore, its death was incidental to that of the girl. Now, before I go any further, I had to give you a primer on the naming convention in Massachusetts. Massachusetts calls its highest court the Supreme Judicial Court because it calls its legislature the General Court. That name for its legislature goes back to colonial days. In fact, the Constitution of Massachusetts is older than the U.S. Constitution. Justice Frank M. Gaziano delivered the opinion of the court in this case. Justice Elspeth B. Cipher wrote a concurrence that, if anything, is even more instructive. the Judicial Court made two important findings, one of which seems to reinforce the other. First, the defendant contended that his girlfriend provoked him to a hot passion by telling him he wasn't the child's father. Now, whether that statement was true or false, the lower court found it false, doesn't matter. What matters is that he believed it, and whether the court should take that as a valid excuse. Of course, nothing could excuse the act completely, but Rocky hoped he could cop it to voluntary manslaughter. The Supreme Judicial Court was having none of that. Tellingly, the court acknowledged that an earlier court had set a precedent for accepting that kind of excuse. That precedent, in turn, relied on English common law, which, according to the court, treated women as property. Adultery, in this case, a common law wife having intimate contact with another man, was an invasion of property. But last year, the court had already suggested that the law must not recognize male irrationality as normal. This time, the court cited an Ohio case holding that the unwritten law letting a man take the ultimate revenge in such cases was archaic and had no place in modern society. Last year's statements might have been obiter dicta, literally by the way sayings. This time the court explicitly disavowed the unwritten law in Massachusetts. They decried what they call the shaky, misogynistic foundation for this law. Emphasis mine. Obviously the court came by that finding from a classically leftist perspective, which brings me to the personhood angle. The Judicial Court acknowledged, first of all, a serious omission in common law. Quote, at common law, the destruction of a fetus in utero was not a homicide, close quote. Again, the court found that an earlier case, and again I quote, examined the foundation for the ancient rule that a fetus must be born alive, and rejected this limitation to the statutory definition of a person, close quote. In throwing out that rule, the earlier court substituted this one, quote, infliction of prenatal injuries resulting in the death of a viable fetus before or after it is born is homicide, close quote. Wow! The earlier case involved vehicular homicide. A prosecutor charges that when someone drives under the influence and causes fatal injuries to others as a result. In this case, Ranchi contended that his knife never touched the unborn child, so the earlier case did not apply. Oh, yes it does, said the court. Again, quoting the earlier case. If a person were to commit violence against a pregnant woman and destroy the fetus within her, we would not want the death of the fetus to go unpunished, close quote. Furthermore, the court considered whether the defendant specifically intended to kill the fetus. Yes, he did, said the court. He had already expressed concern, well-founded or not, about her natural methods of prenatal care. So when he wielded that knife to deadly effect, he knew perfectly well what he was doing. The Judicial Court affirmed the personhood of the unborn child in other ways. Now, before I get into what those are, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, the employment issues, unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. let's get into these other ways. To paraphrase Elizabeth Barrett Browning, let me count the other ways the Massachusetts Supreme Judicial Court affirmed personhood for the unborn child. In that case, did the judge act within his discretion to sentence Raunchy to 2 consecutive life terms? Again, yes. One for the mother, the other time for her viable fetus, all within the discretion of the trial court. The trial judge's charge to the jury affirmed personhood again. The judge put it this way, quote, "A killing is not murder unless a human being has been killed. A viable fetus is a human being under the law of homicide. A fetus is viable when there is a reasonable likelihood of the fetus' sustained survival outside the womb with or without artificial support." Close quote. Note that last phrase carefully. With or without artificial support. Note also the earlier phrase, reasonable likelihood of sustained survival. This precedent is a direct blow against the new California rule that seems to allow infanticide. In Massachusetts, at least, ending the life of any unborn child that has a good shot at life outside the mother is murder. That applies whether said unborn child would need ventilatory or other support or not. For any highest state court to make such a rule breaches the wall of sacrosanctity of what gets called a woman's right to choose. Massachusetts has indeed come a long way since the Supreme Judicial Court acquitted Dr. Kenneth Edelin after he ended a pregnancy just before delivery would have taken place. And again, how he did it, you can look up. I flatly refuse to describe it here, though I will say that it created a sensation on national television and what were then called all 3 networks in the springtime of 1976. But you want to know something really wild? The late Dr. Edelin, he died in 2013, won Planned Parenthood's Maggie Award in 2008 for what he did. Now, Justice Elspeth Seifer, in her concurrence, cited another interesting fact. Homicide is now the leading cause of death in pregnancy, and indeed outpaces the next 3 causes combined. Those causes, familiar to any obstetrician and gynecologist, are toxemia of pregnancy, associated with severe heightening of blood pressure that can, but does not always, cause seizures. Hemorrhage and sepsis, meaning an infection in and of the blood. Indeed, she cited an article in Obstetrics and Gynecology, and I've left a link to it in the description, saying that more than twice as many women die from acts of murder during pregnancy and for 42 days after delivery as from all other leading causes combined. Then she came to the point. The state must crack down hard on this kind of violence. Thus, a leftist court has affirmed the personhood of an unborn child, albeit at a late stage of development, and they did it in order to affirm the most severe punishment of a murder convict short of his execution. A decision that started with the repudiation of the unwritten law, not to mention the code of machismo, ended with an affirmation of personhood for unborn children. To paraphrase Justice Seifer, the Massachusetts Supreme Judicial Court took a laudable first step. But that court has many other precedents to override to achieve a completely satisfactory result. Chief among these is Commonwealth v. Edelin, 1976, which Justice Graziano specifically cited. Nevertheless, this victory will last precisely because a court granted it from a leftist perspective. Nor should any man hold any brief for Peter Raunchy or anyone else who does what he did. Machismo can never be an excuse for such behavior. More to the point, I will gladly throw that kind of macho man to the she-wolves as the price for affirming personhood for any unborn child. And now I'm going to leave you with this quote. Well, a partial quote anyway, from Matt Staver, the head of Liberty Counsel. It makes perfect sense to charge a person with murder who kills an unborn child. It makes no sense to call this choice when the mother does the killing. Homicide can only be committed against a person, a human being. Homicide cannot be committed against property or a non-person, plain and simple. Ending a pregnancy, except I assume an ectopic pregnancy, becomes homicide because the act of killing the child is the same, whether it is done by a violent actor or a doctor in a white lab coat. Close quote. The Massachusetts Supreme Judicial Court didn't go all the way to full recognition of that fact at all stages, but it just took a giant step in that direction. Links to the description of the article, to the decision in the case, to that other article in the OB-GYN journal, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to oursilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel and links to 3 videos I've done talking about where we are on this issue after the United States Supreme Court made its decision in Dobbs. This is Terry A. Hurlbut delivering another Declaration of Truth and reminding you to let the truth set you free.